If you got the brains to jump that power, can you close the deal in the final hour? Spin to the shoes to the legally lead. Are you a shark or just slash me? Could you be a big time Manhattan lawyer? Attentions, protections, high stakes seals. Only the best know how it feels. So bring your wits, bring your pride. Big time lawyers don't sleep at night. Could you be a big time Manhattan lawyer?
My name is Big Bad Babo, and I'm the host of this, the first and likely last episode of Could You Be a Big Time Manhattan Lawyer? Let's meet our contestants. Summer, tell us about yourself.
Hey, Big Bad Babo. This is Samar Shah. I'm a patent attorney. I worked at a Manhattan law firm, I guess the Manhattan office of a national law firm for a little while. It was fun. I don't know if I could cut it, though. This will be the test.
So how many years do you have?
How many years have I been practicing?
Yeah, big legal.
About 12 years. 12 years or
Okay.
so. Yeah.
How many years experience do you have as a big time Manhattan lawyer?
Not a whole lot.
Okay, well, thank you, Summer. We're moving on to our next contestant. Ian, tell us about yourself.
I'm Ian Holloway. I'm a patent agent, but previously was a patent examiner. And I visited New York a couple times.
So you never worked as a big time Manhattan lawyer?
No big time. No, I'm just a country boy out here. Yeah.
All right. So our contestants have a combined 12 years experience, 12 years legal experience, and we're going to find out whether they can be big time.
Bobby, you worked at the same law firm as I did, and we had the New York office. And if I recall correctly, the New York office of the firm we worked at was used as a location for recording some shows, legal shows. Is that right?
Maybe. That sounds right. And I can tell you, I found out very quickly that I was not capable of being a big time Manhattan lawyer when we did that. I remember one Saturday I went to a Georgia Tech football game, and back when we had Blackberries, the game ended, and I had it was Saturday afternoon. I had a little beeping red dot, and I had 30 missed messages, and it was hey, Bobby, can you look at this? Hey, where's Bobby? And they started adding more and more big time Manhattan lawyers on the email chain, being like, can we send a welfare check for Bobby? That day, I did not go look at that message. I started looking at, started hitting up the recruiter. Anyway, that day he needed me for something. I don't even remember. It's stupid. Anyway, today we're going to be looking at season 1, episode 2 of Suits. Well, I said looking, but I only pulled audio clips. And it's kind of a good thing because there was like a distractingly good looking actress on this show. I saw she was in a Miller Lite commercial, and I did a deep dive, and I found out her name was Meghan Markle. And I did some Googling. I didn't really see much else that she did, but this show was great. And I think she's going to do good things now that Suits LA is starting. So look forward to seeing her.
I think she has a bright future ahead of her. I'm looking forward to see how that goes.
So this episode is called Arrows and Omissions. I don't watch Suits. I've only seen this episode, although I've seen this episode about 20 times. My understanding is they don't typically take on patent cases. So this is the patent episode. So this is our chance to see how big time Manhattan lawyers will handle a patent situations.
As written by LA writers, right?
I don't know. We're going to find out. So this episode first aired in 2011, which is going to be relevant later.
Yeah, no, this is good because this my big picture takeaway of Suits. I watched a lot of it back in the day. I haven't watched it recently, but it's like if you can take 6 years of a lawsuit, compress it into about 40 minutes of interesting stuff, then yeah, like 6 years has enough interesting things to fill up 45 minutes. And that's every episode of Suit. It covers about 6 years of litigation. So that was my impression. So that's what I was expecting going into this episode. I was like, okay, they're going to compress a 6-year patent lawsuit into 45 minutes. And it wasn't exactly that.
We'll see if your expectations were met. So I have to set up this first clip. So we have our big time Manhattan junior associate. He's playing air hockey with a tech startup founder. The big time Manhattan partner comes over and tells them it's time for a meeting with VCs. The founder has invented a phone that fits in your pocket. It is looking
wow.
And he's looking for his $20 million prototype. Remember, it's 2011. The big time Manhattan partner pulls the prototype out of his pocket. This exchange happens between the big time Manhattan associate and the big time Manhattan partner. Summer, play clip B.
$20 million prototype, yes, and you don't even get to look at this bad boy until after we close the deal bill.
So this clip establishes that the big time Manhattan associate has not seen the prototype, and he doesn't even get to look at it until the deal is closed. All right, so now the big time Manhattan associates and the founder, they're headed into the meeting with the VCs. What would a big time Manhattan attorney do next? I'm going to let you guys talk, and then we're going to play the clip.
Oh man. Ian, do you want to take a shot at this?
Oh my goodness. Let's see. How many times have I gone in to a meeting with VCs with any of our inventors? It'll be 0 times so far. But if I were there, I'd hope to have at least some documentation, some patent pending status to hold up, some filing to show that we're in possession of this invention. And I should hope that I know a little bit about what the invention is to be able to defend that, and maybe what's out there and how we've distinguished ourselves across that. If I'm walking in as that junior associate right now, I'm just there to take notes and look pretty, I think, with that amount of information.
I think that's right. And with Suits, they do try to cast the pretty big time lawyers.
You fit right in, Ian. I will say this. I've sat in a bunch of investor meetings where the client's bringing me along as the IP attorney, and they're like, hey, our investors have questions about intellectual property. Can you answer them? So yeah, but that's usually after I've been working with a client for a few years, usually, right? Like we've done a couple of patents. We know it, we're intimately familiar with what the invention is and the product is. I have never done a meeting like this without knowing what the invention is or having seen a prototype. That's for sure.
Well, I will also remind you, these guys aren't patent attorneys.
Yeah,
But,
that's true.
all right, y'all's answers are in. Let's hear the answer.
What do you think you're going? Into the room with the people? Wrong. That's the adult table in there, and you haven't earned the privilege yet. Well, I play air hockey. Well, you need to go back to the office and file a patent to the front now. Not to file a patent. Figure it out.
So the answer is you have your big time Manhattan associate who hasn't seen the prototype and doesn't know how to file a patent. Go back to the office and file a patent. So what do you guys think about that? Discuss.
So this person has not passed the bar yet, we're assuming, since he doesn't know how to file a patent, and he's going to be representing somebody else in front of the patent office. I believe there's something against the rules there a little bit.
Yeah.
He doesn't even have a technical background as far as I know, but
Oh my goodness.
Yeah. Wouldn't be able to
I
sit
didn't watch
through the
the
patent
shows.
bar. I don't think he does have a technical background, from what I recall. But yeah, I think I guess, there is illegal practice of law, right? That is actually throughout the whole show. So, why not break another legal ethics rule,
Good point.
the
Yeah,
patent
why
bar
not?
ethics rule, right? Why not?
It's
Okay.
ironic. The inventor would be more appropriate to file the patent and write the patent than our attorney is right now.
Yeah, and I'll say this, when I was watching this episode, I actually got super excited because I was like, oh man, they're going to introduce another character who's a patent attorney, and that patent
Yep.
attorney is going to be awesome and badass, right? Let's go. So that's what I thought they were going. They were like, he doesn't know how to file a patent. There's got to be somebody else at the firm who's a patent attorney who knows how to file a patent. And I was like, of course, that person's going to be badass, but we'll see.
Well, I think they do introduce a new person. So moving on, if you were a big time Manhattan attorney not specializing in patent law, how many patent applications do you think you would file? So and what I'm talking about is a new person. He is I believe, a senior associate, and I believe he is not a patent attorney. So a big time Manhattan senior associate who's not a patent attorney. How many patent applications would you expect them to file?
0, not allowed
Yeah.
to file any.
Okay, 0. We got answer from Summer. What about you, Ian?
Oh yeah, we got a big 0 there.
And instead of watching the deal close, so you thought these people? 100, like
The answer was like 100.
Like 100.
So that's a weird answer, right? For like, even if this guy was a patent prosecutor, you'd expect it to be way more than that.
Yeah.
Yeah.
But But if this guy wasn't, you'd expect it to be 0, as you both said. So strange answer.
Yeah.
But I mean, again, we're not big time Manhattan attorneys. So
That is true.
that number
It's-
seems
yeah.
big to us. So how long would you expect for a big time Manhattan attorney to file a patent application on an invention he's never seen?
Well, how long to draft the whole thing?
How long to draft the application and submit it to the patent office?
Well, it sounds like for a cell phone, we've got a lot of technical detail there, but you don't know anything about it. You could probably put one together about what you know in just a couple hours, since
Oh.
you'd know nothing.
Okay.
But it wouldn't be a very strong application, right?
Okay. All right,
Yeah.
Summer.
I'd go the other direction. I mean, so at my big time law firm that I used to work at, it would take us anywhere from 10 to 15 weeks to put a patent application together. From the time the client brought the invention to us to the time we filed something, it'd be about 15 weeks or so usually.
Well, you're
And-
trying to put together a good application then, Summer.
Well, yes. But the other part is usually the company itself is evaluating before it ever comes to the law firm. They evaluate and they sit on the invention for 10 to 15 weeks as well. Just kind of going through the, analysis phase of whether it's worth it to file a patent application, whether it makes sense to file the patent applications. Usually, by the time somebody comes up with something to the time that they file something, probably 30 weeks or so.
So we got Ian with a few hours and Summer with 15 to 30 weeks.
Please tell me that you filed that. Patent? No, not yet. I gave it to you yesterday.
Yeah, the answer is the same. Is correct.
Got me.
But what do you think? What do you think could hold up a deal for a big time Manhattan lawyer? They're in the meeting with the VCs. What do you think could hold that deal up?
Gotta be patents.
Yeah.
Everybody's waiting on patents. One thing I guess I would say is I've never seen a client build a complicated prototype before filing patents if it's that important, right? Or usually the patents come first and a year later a prototype shows up, right? Or 6 months later. So yeah, this is all sorts of backwards so far.
Okay.
But maybe things are different in Manhattan.
Yeah. They
What do you
move
think could
fast
hold
there.
up the meeting? What do you think could hold up the deal, Ian? You haven't been in that room, and neither have I. But we're just speculating.
No, just speculating on what's holding up this deal.
The answer is confirmation that the big time Manhattan non-patent attorney filed the patent application to the invention that he never saw yesterday.
So we're looking for a filing receipt. Is that what?
I think that's what the confirmation is. Yeah.
Okay.
Yeah, this is complicated because they don't say it, so it almost seems like the patent would be granted, right? Is that what they're trying to tell the audience, that like, hey, the patent is confirmed as in it's filed, or as it's granted as in like the patent office approved?
Well, we're gonna get really, really fuzzy on that, but I think they're saying the filing receipt. But
Okay.
Because granted, I don't know if you've seen the patent backlog right now, but I think it's about up to 800,000 at the
Yeah.
office.
well, how does the USPTO communicate with a big time Manhattan attorney? You guys have guesses?
Well, I would say electronic communication. So well, this is assuming that you are registered with the patent bar. You pass the patent bar exam. You register with the patent office, and they direct all communication with you. So when you file a patent application for a client, you usually have a power of attorney, which means that you are going to be the point of contact for this application, for this applicant, for all purposes at the patent office. So usually you'll hear back from the patent office electronically or in the mail.
So you're saying you would identify yourself as the attorney of record.
Yeah.
In
Yeah.
a year and a half, you would start getting communication from
Yeah.
Yeah, that's right.
Now we're 2011. Oh, I was at the office then. That would have been. We still use fax and things like that.
Fair enough. So the USPTO contacts the client of the big time Manhattan attorney within 24 hours and tells them that another submission within 24 hours reads on it. These big time Manhattan lawyers must have those Elon Musk AI patent examiners.
They got the patent office on speed dial, man. There's a special examination unit dedicated to this law firm.
I'd say even calling trying to get a special status on an application doesn't go that fast.
I'm trying to think if I've ever had, calling an examiner, like, do they ever pick up the phone the first time?
We had our paralegals call the patent office for something, not the examiner, but just like the paperwork office. And she was on hold for like 3 hours. She's like, I finally just hung up.
All right. So we've now established that we got another party that beat us to the patent office. What does a big time Manhattan attorney do now?
Well, and I guess before we get there, patents are published 18 months after they're filed. So the patent office wouldn't, like an examiner or somebody at the patent office wouldn't be able to find this other filing that's been filed less than 24 hours ago. They would have to wait 18 months before it comes to light, before they can even access that document.
The examiner is looking at both of them. What if both, since it's the exact same invention, apparently, what if both inventions were assigned to the same examiner?
Well, that'd be a miracle at the office.
Beat you to it less than 24 hours ago. That prototype was sitting in your pocket?
So more boring patent office stuff. A patent, once you file it, gets assigned to an examiner roughly 12 to 18 months later. So an examiner doesn't even have it in their desk or in their queue of things to work on for 12 to 18 months. So like really nobody has it at the patent office yet. So yeah, that'd be pretty much impossible.
All right. So we don't know what to do. Well, let's see what a big time Manhattan attorney would do. So you call the patent office and you get them to tell you the name of the other patent application owner, which is used to reject the patent submission you submitted less than that day. And then you look for a judge to issue an injunction against an earlier patent application filer to stop them from launching their product.
I think that's amazing. So this is assuming that you were told by the office that your patent's invalid,
right?
And that you didn't get any evidence of it at all. You're just like, oh, okay.
Well, also, if you have a patent, like the other party would be the one preventing Wyatt from launching his $20 million prototype. So this is to a non-big time Manhattan attorney. This is a little confusing.
This is incredibly confusing.
Yeah.
It's like you said, Bobby, there's so many places where you're like, oh, this doesn't make sense. This doesn't make sense. If you stack it all up, it really doesn't make sense.
Yeah.
All right. Where do you guys think the big time Manhattan attorney files the injunction?
Well, it's got to be in Manhattan court, right?
Well, yes, but I mean, I'm saying they're going to take it to federal court. It sounded like he wanted to do some judge shopping. So, to me, it seemed like maybe he's not going to federal court.
Yeah. It's got to be. It's federal court. It's federal jurisdiction.
So Southern District of New York?
Yeah.
That's where big time Manhattan? Okay. All right. Okay. So this one's a little unclear. You guys know how on Seinfeld or SNL, they'll show the outside of the coffee shop and then they're in the coffee shop?
Yeah.
So they had 3 shots of courtrooms, and I took pictures of it and I put it on because I couldn't tell where it was, and I submitted them to pickardia.ai, and it said with 100% certainty that they all came from my house. And I was like, oh, it's just reading the metadata. So then I uploaded them to Facebook and I sent the links, and this is what I came back with. One of them, it said with 93.75% confidence it was taken in Pensacola, Florida. It turns out that's wrong. I'll tell you how I know that later, but it said with 94.3% confidence, one of them was taken in New York City. And then with 94.38% confidence, one of them was taken in Weehawken, New Jersey. And I don't believe the producers of Suits were going up and down the Eastern Seaboard to get, establishing shots for a court. So I was like, this isn't right. It did actually, when the scene ended and they were at the outside, the court step, you could see you could see an address and you could see the one that lined up with Pensacola. And this was the New York. This was, let me see, 60 Central Street, which is the New York State Supreme Court. Now, I do think one of them they used for the establishing shot was the Southern District of New York, but I'm going to go ahead and say they were at New York State Supreme Court because I know for sure that they were there in the scene that came after the courtroom scene.
That is some intense sleuthing there.
And they had the New York State. They had a state seal. Now it was zoomed in, and they had the New York flag, and I did not see an American flag. So I'm
I-
gonna
I-
say they took their injunction request, which was denied, to to the New York State Supreme Court. Which, by the way, I looked it up. They do have they are, so it's not like federal Supreme Court where there has to be a first ruling and then they're they could actually hear. I don't know about a patent injunction because they wouldn't have the federal
Yeah.
jurisdiction, but they could hear like an injunction request. Okay,
Well, I guess it depends on your basis for injunction. There might be some injury here.
you think this is gonna go well? All right, let's hear how this court appearance goes. So my takeaway from that is that we know that the other big time Manhattan lawyer thinks that the USPTO is the only judicial body that should be handling the injunction dispute. So any other observations or thoughts?
I'll let Ian go down on this. Yes.
Oh, Summer, you're the one that's appeared in court on these kind of things. I'm lucky I haven't had to sue anybody. So
Well, I guess we should start with how the Patent Office is not a judicial body at all.
Yeah.
It's an administrative body. They don't have any judicial decision-making power other than the ones that are administrative in nature, right? So now the laws have changed since then, so there is some judicial function that the Patent Office will do, but it is by no means the final or the only say in the matter, right? So anything that Patent Office does is actually reviewable by a federal judge, and in fact, yeah, they don't have a lot of judicial decision making power. It's not a judicial body at all.
Okay, any more thoughts, Ian, or should we?
no, I think that sums it up pretty well there.
Okay, so having had the injunction denied, what does a big time Manhattan lawyer do next? And this is the point where I will remind you guys this episode aired in 2011.
Got to go back to the Patent Office, I guess, if they're the ultimate decision making authority.
Well, that's some big time Manhattan lawyer thinking right there.
It just seems all, like you said, it's a twisted knot of logic throughout this whole episode.
You're going back to the offense to file an interference claim with the patent office. Wait, wouldn't that? Would how they determine who wins these situations? It's not always filed first, so why didn't we do that in the first place? If it takes longer, now we're the head velocity off of the patent.
We're going to
So-
do an interference claim.
Initiate an interference as a last ditch effort because it takes longer than the injunction at the New York State Supreme Court, preventing the patent applicant from practicing the subject matter of their senior patent application.
Oh my goodness.
So I will note the interferences are not available for patent applications filed after March 16th, 2013. But we know that both these patent applications made that deadline because they were filed within a day of each
Right.
other in 2011. So I've never done an interference. Summer, have you? Or have you, Ian?
No. The only thing we talked about that at the office was just, I mean, you could start them as an examiner
Right.
or suggest them, but the general view is that it just destroys both parties' patents in the end. Everybody loses, nobody wins during an interference.
And if you were to do that, you would make an amendment to make the claims of the junior one exactly the same as the senior one or something like that.
Yeah, I think mostly what ends up happening is both sides find art that is going to obviate or anticipate the claims in both of the applications.
So it's like a suicide tag.
It is, yeah.
This is why Harvey doesn't want to do it. There's something true here. I mean, I would expect an interference proceeding to take longer than an injunction hearing. I mean, none of them is going to happen under 24 hours, but you can get an injunction hearing sooner, probably within a month, and the interference proceeding will take close to a year, something like that.
But is it the case that if you're doing an interference, you're dealing with patent applications, whereas if you're doing an injunction, you're dealing with patents? And
Yeah.
again, back to he had to be the senior patent holder to get the injunction, I would think.
Well, there are other remedies that you can ask for, right? That are not patent remedies. So like you try to get an injunction that way. There's
Right.
some-
So maybe the New York State Supreme Court is the right venue.
Maybe, yeah. But they're not going to hear anything about the patent. Maybe they'll hear about some
That's
other
why
damage.
The
Yeah.
USPTO, the attorney saying that was the only judicial body. We
And-
have our client who spent $20 million to make a prototype of a phone that fits in your pocket. The entire financing deal was contingent on confirmation of a patent filed that the big time Manhattan partner didn't even think about until on his way to the meeting. And then the big time Manhattan associate took 2 days to file the patent there's another entity that filed a patent application within 24 hours, and the USPTO has declared that the patent's applications overlap and you are the loser. Your injunction was denied. The interference is going to take too long. The patent applicant that beat your filing date is asking for a $20 million settlement. Not entirely clear what they're settling. How does a big-time Manhattan lawyer handle this?
Man, it's got to be through trickery and sheer legal guile is what I expect at this point.
Wait till you guys hear this. All right. Pay close attention. This is pretty long. And if you're not a big-time Manhattan lawyer, it's pretty confusing.
Ladies and gentlemen, I'm terribly sorry, but we have a problem.
What problem? We came down here because you led us to believe that your client was ready to accept our settlement agreement.
And I thought he would. Look, I took him the offer. I presented it to him and recommended that he take it. In fact, I urged him to take it. You know what he told me to do? He told me to tell you to shove it up your ass.
I know you didn't have me come all the way down here just to tell me that.
You're right. That's not all I said. He said, rather than spending years fighting this out in court, in 48 hours, he's going to put in this online.
That's a little wrong, but you did the idea.
What are you showing us? Is this a website?
Available at the Suntech domain name.
All the design plans and calculations have been uploaded,
Is this online now?
Can be.
which means the whole world will have access to my designs.
We'll need 10 knockoffs of that phone before you even catch a cab back to your headquarters.
We could file an injunction.
Not before tomorrow, and once that technology is out there, good luck putting that genie back in bottle.
Well, then I'll sue.
But my client won't have any money. What he will have is credit for the initial design, which, after he incorporates under a different name, will be worth a hell of a lot more money than the $20 million that you're offering.
The answer is we have our client, the junior patent applicant, threatened to put his design plans on the internet, which will render his product worthless, according to him and his big-time Manhattan lawyer. This threat to render his patent application worthless somehow gets the senior patent or patent application holder to pay him $400 million.
Wow.
That's why big-time Manhattan lawyers command those high billable rates.
That is something. Yeah.
I could never have thought of that strategy, honestly. So I would have thought it would be a terrible strategy.
I mean, but the $400 million says otherwise.
Yes.
Brilliant.
Next is investment.
Brilliant.
That's all I have for you guys today.
Thank you for joining us on the Patent Pending Made Simple podcast. I hope you enjoyed our show. If you'd like to receive updates, view the show notes, or access a direct link to any resource, go to the episodes page on patentpendingmadesimple.com. To help others find our podcast, please like, share, and subscribe. Thanks again for tuning in. I look forward to having you with us next time on Patent Pending Made Simple. This podcast has been hosted by Outlier Patent Attorneys and is not intended to, nor does it create, the attorney-client privilege between our hosts, guests, or any listener for any reason. The content of this podcast should not be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.